Happy Tuesday. It's time for coffee and Cursey words. I know you're like, Emily, you're late. I know. I was doing hair and makeup. I've got a lot to film today. True story. So that's what was going on. The camera's like, we're just getting set up. It feels like a Monday and I'm still under the weather. How are y'all? Where are you coming in from? What are you drinking? I've got coffee. We're doing just a couple quick stories today and then a lot of questions. I feel like it's been days since we've gotten to do questions because we've had so many topics to cover. So we're going to try it. Kat Nag. So YouTube has a new option that we are trying out on stream. We're just kind of playing with some of the new options. I talk about streaming a lot, and YouTube added a subscribers only chat mode. So we're playing with it. We will take it off. I just want to see how it goes and I want to see how it works and what the experience is for you guys and for the mods, because it's an interesting option that you can do subscribers only chat, members only chat, or just all open chat. So we're just kind of giving it a whirl. So we're trying out some new stuff. Replay crew, there will be timestamps down below. A lot of today will be Q&A. So good to see everybody. Hello, Taiwan. Good to see you. Hello, New Jersey. Everybody has coffee. I love it. Lots of you coming in from Tennessee, Italy. Good morning. Somebody's coming in from the Mile High City. Hello, hello, hello. Let's just get into it. We have lots to talk about. And then if it is your first live, I will definitely ask and we'll get to see who's coming in for their first live. Hello, Paraguay. Good to see you. I hope I pronounced that properly. Hello, Scotland. Lots of you from Chicago and London and Singapore. Uh-oh. It's hot everywhere in the US right now. It feels like it. All right, let's just get into it. We got stuff to talk about. Hey there. If we haven't met yet, I'm Emily D. Baker, the badass lawyer and everyone's favorite legal commentator. I'm the host of The Emily Show, and I break down the legal shit behind the news and pop culture stories we all want to talk about. I have been a licensed attorney for over 15 years, but this is not legal advice. I should warn you, I'm a big fan of the Cursey words. This channel is where the law nerds unite to talk about facts, not fuckery. So if it is your first live, go ahead and put a 1 in the chat. I don't know why my video is buffering. If it is, I'm sorry. I see it on my end too. Hopefully the sound sounds good. It's just going to be like that today. It just is. So we've got, as I said, a few quick stories, but it's good seeing where everybody's coming in from and whose first stream it is. If you are getting buffering, please go ahead and refresh the stream. Oh my goodness, so many of you coming in new. So many of you. And of course, my StreamYard has stopped working. So we're just gonna give it a minute. I don't know why everything has frozen on my end. Sorry, y'all. We've got lots of overclocking happening here. My computer is just struggling. I don't know what that's about. Computer, don't do me like that. And my StreamYard lost all of my beautiful ones. I saw so many of you coming in for your first time, and I try to pull those up so much, but I can only do it when the tech is working for me. So thank you, Debbie. I have lots to film today. We're in like full filming phase. So let me try to catch up. Hello from the Philippines. Hello for all the first timers. I'm going to try to let this lag catch up for a minute. Sorry for the stream issues. Dawn Nash, just hit the subscribe button here on the YouTubes and you'll be subscribed. That's all you got to do. Totally free. And then you're a law nerd and you can say, I am a law nerd. Taylor, I love it. I love bright purple hair. It's so fun. Hello, Montreal. Hello to all of you coming in for the first time. It looks like the lag has caught back up. I don't know what was going on with my computer. It had a minute. It definitely had its own moment there for a second. So sorry about that, y'all. It's gonna be one of those days. It just is gonna be one of those days. So we have some quick stories real quick, and then we'll keep going. Usually in the replay crew, welcome from Germany and good to see you. Hello, Scotland. Thank you. Hello, Jersey. Always Jersey. Made it to alive. Welcome, LB. Woohoo. All right. Wisdom tooth out iced coffee. Karen, yes, fair enough. Wisdom teeth can be just yep. All right, let's get into, one of my stories disappeared. Hold on. Get back here. Get back here, story. I wanted to talk about Facebook real quick, and then we're going to talk about Triller, and then we're going to do a lot of Q&A because we have had so much. I've talked so much Britney, so much Housewives. We just have not had time to get into deep Q&A. So we're going to get into a lot of Q&A today because we haven't had time to get into as much Q&A as I normally do. And I miss it. And B, I think it's helpful to really get into those questions and see what is going on. I know a lot of you have had time to catch up on the Britney content, the Housewives content. So that's what we're doing. Let me get into my first story about Facebook. Once everything pulls up, of course. We're just going to have stream issues today, aren't we? Just stream issues. Hold on. Give me one sec, you guys. I know we are having stream issues. We will timestamp it down below. Give me one sec. Let me refresh on my end. Sorry, y'all. We'll be right back. Well, that's no fun. We're still lagging. Sorry, y'all. Hopefully it'll refresh itself and catch back up. Thank you all for the super chats. It's just, we rarely have stream issues. Today is going to be one of those days. Oh, and of course it shifted my mic. Thank you, mods, for letting me know. Today. You know, you stream enough, eventually it's going to be a problem. Are we back? Yay! I think we're back. You guys, replay crew, sorry about that. We'll timestamp it down below. I actually might cut this out on the back end after this. So if you don't see the live chat in today's live stream, it's because I cut out the tech issues. It's going to be that kind of stream, y'all. What are we going to do? Let's talk about Facebook. Let's talk about Facebook real quick. Facebook's been going through these antitrust suits. I've talked about them a while back. Some of it was like, really, is this what we're doing with antitrust? Because the purchase of Instagram was approved. And so it seemed odd to me too, that when the purchase was approved, that then the US government was trying to undo it. It was so weird. It was just so weird to me. It was just so weird. So let's pull up these stories. If it allows me to, we're going to pray to the tech gods. that it pulls up. We rarely have stream issues, and I just get so annoyed. I get so annoyed with it. So let's see. Fortune magazine. Let's go to their head first, and then we'll go over to Law 360. Why? Because I like the Fortune headline better. Share screen. Let's do it. Let's do it. Come on. Ooh. I don't know why this one is so rough today. I don't know what's going on the back end of this stream, but this computer is rough, and I have a long day ahead. So hopefully this sorts itself out. This is just not going to pull up. Let's try one more time. Let's try again. Nope. All right. Well, if it pulls up, I'll pull it up. Everything is just struggling right now. The headline from Fortune is that the FTC fumbles its big antitrust case against Facebook. That is absolutely what happened. The judge dismissed the case. What's been going on is that the FTC has been trying to bring a fairly large antitrust case. A lot of it had to do with anti-competitive and monopolistic behavior that was alleged. And, there we go. We have a screen share. Look at that. Yay. Now, if it'll scroll, maybe we'll get back to, no, paywall. All right, Fortune, you had a sassy headline, but we're not doing a paywall. The FTC fumbles its big antitrust case against Facebook. It took that long to pull up, and it's paywalled. Of course it is. Okay, fine, Fortune. We'll go back to Law 360. It's paywalled, but I pay. So we'll just do that. I was trying to pull up something that you guys can also pull up that you don't have to pay for, but nothing is pulling up. So let's go to the Wall Street Journal. I know you guys all I tried to pull up a wide variety of news sources so everybody can pull up a news source that they like. This is being reported everywhere. It's being reported basically the same everywhere because there's not much to say. The judge did the thing that the judge did. The federal judge dismissed the antitrust lawsuit against Facebook filed by the government and most states. I broke this down on the channel if you want to go look at it. The district judge on Monday granted the social media giant's request to dismiss the lawsuits filed by the FTC. The dismissals, which came in a pair of rulings, came before any pretrial proceedings had progressed. They said that the FTC's lawsuit was legally insufficient. We've heard this. Insufficient on its face because it didn't plead enough allegations to support monopolization claims against Facebook. The judge said that the commission can try again and gave them 30 days to file an amended lawsuit. This is exactly what we saw on the motion to dismiss with regard to Ice Cube and Robinhood. It was like on its face, there's not enough here to go forward with this lawsuit. But you have, in that case, it was 21 days. In this case, it's 30 days to fix your shit and bring it back. Bring it back, y'all. Bring it back, y'all. Bring it back. So this Law 360 article is a bit more in depth. I enjoy Law 360. No, it's not sponsored, but they add all of the PDFs and stuff. So let's pull this up a little bit bigger so you guys can see it along with me. But the FTC had accused Facebook of monopolization and sought to unwind the purchases of WhatsApp and Instagram. If you want to go look at my content regarding this lawsuit, I broke down the behavior that they said was anti-competitive. The thing that always bothered me about this lawsuit is that the FTC gave approval and the US government gave approval. So how can you say it's a monopoly after the fact? And though I am not generally empathetic towards big tech, I have lots of big tech questions and healthy amounts of suspicion for everything. But how can you say years after you granted it, oh, by the way, our bad, now we've got an issue. There are some practices there that are questionable. Are they monopolistic? There's some app store behavior I don't like. There's definitely some Facebook behavior that is questionable to me, but the owning of WhatsApp and Instagram just isn't it. The government approved it. And Facebook's argument was a lot like the Haley Page argument. It was like, we built this bitch. So part of Facebook's argument was, look, Instagram today is not what Instagram was when we bought that shit. So you can't say it's a monopoly today, because when we purchased it, it was so different. We built it to what it is today, and it's not our fault that it's better and people like it better than other things. We built Instagram to be what it is today. We built that in, and part of the reason it is what it is because people can easily connect it to Facebook. So Facebook's argument is, we built this shit, and it wasn't a monopoly when we bought it, and you approved it when we bought it. So let's get into what the court said a little bit. The district judge issued orders in each case granting Facebook's motion to dismiss and allowing the federal enforcers to amend. The judge found that the FTC's case failed to show that the company has a monopoly power in the market for personal social networking, saying that the agency makes only the naked allegation that Facebook has a dominant share of the market. You have to bring a little bit more than Bueller conclusory statements. This is like the Triller judge. You can't just say shit and have it be sufficient. The judge in the original Triller cases. You can't just say shit. You can't just be like, but they do. Obvi. Like, that's not enough. And so that's what's happening here. It's a win for Facebook, I think. But I don't think the government's done fighting over Facebook's potential anti-competitive behavior. Though I think the anti-competitive behavior pointed out here isn't as much to do with Instagram, but it's more the way that Facebook blocks other companies from gaining market share. Whether they can turn this to, or bring another suit to deal with that, the fact that if you don't play along with Facebook, they won't allow login with Facebook and other things that can hurt apps down the road, would be interesting to see. So moving on, such an unsupported assertion might barely suffice in a monopolization case involving a more traditional goods market, in which the court could reasonably infer that market share was measured by revenue, units sold, or some other typical metric, the order said. But this case involves no ordinary or intuitive market. What is the market for personal social media is what the court's saying. Like, what even is that anyway? What even is that anyway? E of Oz, we're going to talk about that next. A number of you sent that to me on the text line, and I saw it this morning and went, yep. So the market share is hard to define. Like, what even is a market share of personal social media? Is WhatsApp personal social media? Or is it a messaging service? Is Facebook personal social media? Yes, but is it also a messaging service because of Messenger? What about Instagram? Like, what is social media anyway? What is personal social media anyway? Is YouTube personal social media? Because it feels like YouTube is a lot of personal social media because you have community tabs and conversations. Then what about, TikTok? What about things that have come and gone since this? So let's keep going. Into what the judge said. The order dismissed the agency's complaint without prejudice, gave them 30 days to amend. The judge found that the state enforcers came too late. So remember, there was the federal government and then literally all of the states suing Facebook. Like literally all the states versus Facebook back in December, noting that the purchases of Instagram and WhatsApp were made in 2012 and 2014, respectively, while the suit was not filed until December 2020. Bish, what are you waiting for? Like, what you waiting for? I can't sing Gwen Stefani ever because Gwen Stefani is a queen and I can't. But you know what I mean. You know exactly what I'm thinking. But what you waiting for is what the court said. You can't wait till 2020 when it feels like the feds are on your side to bring this suit. If you had issues, you should have brought it at the beginning. The judge tossed the state's case entirely, finding that the enforcers could have filed the suit 6 years ago, but did nothing over the last half decade. You don't get to amend. Yeet. So that one got yeeted. So we'll see if the FTC comes back, but the states can't come back. The court is aware of no case, and the plaintiffs provided none, where such a long delay in seeking such a consequential remedy has been countenanced in a case, continuanced, in a case brought by a plaintiff other than the federal government. Right. The federal government takes time, but y'all don't have that luxury, against which latches do not apply, and which the federal antitrust laws grant unique authority as a sovereign law enforcement. The order said, if latches is to mean anything, it must apply to these facts, even in a suit brought by the states. There you go. Thrown out due to latches. Should we do a law? We need to. We need to do a longer definition of latches. We've done it before. I'm going to give you the official definition and then my definition. The longer definition of latches is you fucking waited too long. That shit's old. But we'll give you the official definition too. From a old Black's Law Dictionary, because I went to law school a million years ago, 7th edition. I don't know what edition we're on a Black's Law Dictionary now. Any law students in the chat, what edition Black's Law do you have? Do you even have the book? Do you do the book? Do you do the book for latches? Do you just do it online? I imagine it's easier to do it online. Look, this is a visceral experience. We get to, like, the book has a smell. Law books have a smell. They do. It still has a smell. We're going to go to latches real quick. This is like all of my anxiety as a kid, like having to go through the dictionary and define things. But I want to give you the real definition in addition to the Lawner definition of that shit came too late. Because that shit came too late is the Lawner definition of latches. And we've talked about latches in other suits. But it's essentially that you've waited so long that it causes that undue delay can cause detriment to the person defending it. It's like if you wait forever to bring a lawsuit, how are you supposed to defend the lawsuit? Like you brought it so long. Let's see. We're on the first page of the L's. Of course we are. Latches. Law, French, reminiscence, slackness, unreasonable delay or negligence in pursuing a right or claim, almost always an equitable one, in the way that prejudices the party against whom relief is sought. I feel like I defined that fairly well. That shit took too long, and it can actually make it harder for the other party. Kate Lim, all right, we're on the 11th edition. We got to update. We got to update that. No, we don't. We'll keep the 7th definition until they put yeet in Black's Laws Dictionary. Yeet is in the Lawner Dictionary. They yeeted this one. They absolutely just dismissed it. The equitable doctrine by which a court denies relief to a claimant who has unreasonably delayed or been negligent in asserting the claim when the delay or negligence has prejudiced the party against whom relief is sought. So, yeah. And then C also, estoppel by latches. You waited too long. You can't bring that shit. That shit's too old, and you can't bring it. So, there we go. Dereliction and delay. See? Dereliction and delay by bringing the suit is a very concise answer. I think we nailed it, though. I think we nailed it. So, the state's case is yeeted. Like, you're not going to get to bring it. Goodbye. Too bad, so sad. I love getting into the fact that the doctrine of latches actually still matters. These are old concepts. I mean, latches goes back to French law, like way back early in the history of law. Like we're talking early days. You could not wait, because here's the thing in law, gamesmanship is a part of law, but if you wait so long that the other side can't reasonably defend it and bring it and go, nah, it's like what? No, you have to bring the thing when it's ripe to bring the thing, and you can't try to reduce it. So yes, yeeting is throwing out. Yeeted or yoted. We're going to, hold on. Sorry, Nightbot, we were not trying to talk to you. Cindy, we are going to do a Lawner dictionary. We're totally going to do a Lawner dictionary. Latches means you waited too long, that shit's old, and you can't do it. All right. In a statement Monday, a representative for Facebook said the company is pleased the judge recognized the flaws in the government complaints. We completely, No, I've added words. We compete fairly every day to earn people's time and attention, and will continue to deliver great products for the people and businesses that use our services, the statement said. A representative for the New York Attorney General's office said in a statement responding to the ruling that enforcers are reviewing the decision and considering our legal options. Your legal options were to bring it, in 2012, 2013, 2014, 2015, not in 2020. Facebook was hit in December by parallel enforcement actions. We know that, but just as a brief restatement for those of you who have not been following along since December, it's totally fair to think. Facebook was hit in December by parallel enforcement actions from the FTC and a contingent of 46 states, the District of Columbia, and Guam. The suit accuses Facebook of violating Section 2 of the Sherman Act, which bars the maintenance of monopolies through its past acquisitions of potential competitors and alleged restrictions on third-party developers. The state's case also included a claim under the Clayton Act, which bars certain deals that reduce competition, that anti-competitive behavior we were talking about. Ooh, we need water. Still not feeling well. Although plaintiff is correct that it is not required to identify every alleged competitor in its pleadings, its choice to identify essentially none is striking, the opinion said. It's almost as if the agency expects the court to simply nod to the conventional wisdom that Facebook is a monopolist. Ooh. The court's just like, yeah, we're not going to just agree with you. You have to prove it. The judge found more salient issues with the case from the contingent of states, saying in Monday's opinion that it is blocked by the doctrine of latches, which precludes relief for those who sleep on their rights. That shit's too old. There's a general 4-year statute of limitations on such claims, and while the states contend that it shouldn't apply since they are bringing a case on behalf of their citizens, the judge found that's not the case. No. There's a general 4-year statute of limitations, and even 4 years is pretty long. But it can take that long to investigate the claims in this kind of large monopolistic case. Plaintiffs waited 6 and 8 years to challenge 2 highly publicized acquisitions, one of an existing nascent competitor, the other of a potential future competitor, by a firm that they allege was already a dominant monopolist, the opinion said. The state's allegations that restrict Facebook places on third-party developers that access its network also fail to state a claim under current antitrust laws. So these are the statements I said that I thought were the most interesting, was the, hey, Facebook punishes people that don't play along, but the court's saying that's not enough here. According to the opinion, which said companies generally have no duty to deal with their competitors, the judge also said, well, it did. No. The judge also said that while it is possible that these policies could be part of an ongoing effort to maintain a monopoly, he did not reach that question because Facebook stopped blocking developer access more than 5 years ago. Such long past violations cannot furnish a basis for injunctive relief the plaintiffs seek. The plaintiffs sought to break up Facebook, Instagram, and WhatsApp and put them all under separate companies, which would have been a fucking nightmare for everyone involved, and probably would have ended up hurting Instagram and WhatsApp and the use of them. So it's very interesting that the court's like, what you're asking for is drastic and what you've proved is very little. The judge said that the FTC is on firmer ground when it comes to the challenge of the WhatsApp and Instagram deals after the court rejected Facebook's contention that the acquisition occurred too far in the past. Precedent shows that the federal government can challenge a transaction as long as the assets are still being held. So the FTC has not been barred by latches. The states have. The court will not speculate further as to how, if at all, the Section 2 analysis of a claim involving a long-ago merger might differ. Facebook has made a number of arguments on this score that need not be addressed below, because the court's not going to tell you what they're going to do. They're going to see if you can fix the complaint first. The court's not going to signal how they're going to rule down the road, because that question's not before them. The court's going to say, hey, see if you can fix your complaint, and then we'll go at it. Let me pull this up so I can see it. Asher said, is it true that Sovsits won't recognize the new editions of Black Law because they redefine what a car is? I have absolutely no idea if sovereign citizens don't acknowledge Black's Law Dictionary. I don't know what Black's Law Dictionary redefines what a car is. I'll have to take a look and see. I don't know off the top of my brain for sure. I know I missed another super chat before we switch into our next topic with Triller. Have you ever had a case that quoted the Magna Carta or had to quote it? Teresa, I have read not cases I've worked on, but I have read cases that quoted the Magna Carta. But they're old. They're old, but law school covers some old cases. But no, not recently. And now it's just, if it comes up, I would definitely laugh if that happened. All right, let us go into this Mike Tyson Triller situation and then get to Q&A, because it's what is Triller even doing right now? I have not pulled up this lawsuit. I will pull up this lawsuit. I actually want to pull up both Pacer. Hold on. I'll pull up both Pacer and LA County. I want to see if there's anything new with Britney. I have not seen anything get filed. I know she's been in Hawaii, but I have not seen anything get filed. And I'll pull that up while we start to do Q&A. But let's get into Triller first. All right. I don't know this website, Clutch Points, but this is the story I was sent multiple times. So let's get into it and take a look. Triller sues Tyson after paying him over $30 million for Roy Jones Jr. fight. Former heavyweight champion Mike Tyson is being sued by Triller over his refusal to work with the app for his next exhibition fight. Triller CEO Ryan Kavanaugh sent a letter to Tyson revealing that the app had spent over $30 million on his previous exhibition bout and already paid Tyson $25 in full for the third fight against Evander Holyfield. Rather than drop the price or renegotiate the deal, we agreed to keep the economics the same with the understanding that the Holyfield fight would be the next fight, and we pre-agreed to terms, Kavanaugh writes. No one else but Triller was willing to take $25 million of risk on the initial fight, especially in the middle of COVID. We did. Every penny paid in full, and no one else has claimed that we did not pay every penny in full. Kavanaugh said Triller sued Tyson in order to prevent him from pursuing exhibition fights that didn't involve the social platform. In March, Tyson posted a message on Instagram stating that he would no longer work with Triller. Just to be clear, there is no Tyson with Triller fight. I don't know any Triller executives personally. I don't have a deal with Triller or any head executive representing them for the next event. I will never do another event or any business with Triller, so anyone misrepresenting that they own the rights to my name or my next, I'm assuming fight, even isn't true. I am not with or ever will be with Triller's Fight Club. Kavanaugh claims to have receipts proving Tyson's financial agreement with Triller. It is unquestionable that we have a contractual right to your next fight, including but not limited to Evander. Having spent over $30 billion on your first fight while being told it was a crazy risk no one would take was only because and for the right to a Tyson Holyfield fight. We also entered into an agreement directly with Evander. Well, that's not the same. Spending $30 million on a past fight doesn't mean they own this fight. The words are very parsed in this. The words are very parsed. Hopefully the lawsuit has the contract. I'll pull it up for Friday. Triller's Ryan Kavanaugh responds to Mike Tyson with a letter obtained by me, affirming that Triller has the rights to Tyson's next fight and claiming there's bank receipts. Tyson was paid in full $25 million for the Roy Jones event. Is this going to make me go to Twitter? Yes, it is. Yes, it is going to make me go to Twitter. Let's see if I can pull up this letter. This is, from 21 hours ago. All right. Well, I'll retweet it so you guys can read the letter. Ooh, okay. Let's pull this up. June 28th. Yeah, that was what? Yesterday. Mike Tyson delivered via email. As you know, I've been an admirer of yours. Well, let's see who wrote the letter. Is this Ryan Kavanaugh? As you know, I've been an admirer of yours for as long as I can remember. I mean, I guess you've had a conversation about that then, maybe. When we founded Triller Fight Club and the opportunity arose to work with you, it was a dream come true. Not only did we get to collaborate with you, we had a chance to expose a new, younger generation of boxing fans to an all-time great. Producing your fight with Roy Jones Jr. was one of the highlights of my career. Oh, how good for you, Ryan Kavanaugh. This is all about you. Good for you. As you know, the initial concept, he doesn't say contract, he says concept, was for you to reunite with Evander Holyfield for a third fight. We agreed to the $25 million price tag for this event. This event, which event? This event, Holyfield, or this event, the Roy Jones Jr. event? I find it unclear. We learned after we agreed to move forward that Evander didn't want to fight and rather Roy Jones did. So we were told by your team. We later learned in fact that Evander expressed he would have fought, but also had issues with your team. I'm confused. I am confusion. Rather than drop the price or renegotiate the deal, we agreed to keep the economics the same with the understanding that the Holyfield fight would be the next fight, and we pre-agreed to the terms. That sounds like there's a contract, but it says pre-agreed to terms. It does not say, and we signed a contract. No, it doesn't say, and we signed a contract. No one else but Triller was willing to take $25 million of risk on the initial fight, especially in the middle of COVID. We did. Every penny paid in full, and no one has ever claimed we did not pay every penny in full. How is that relevant to anything, though? Like, how does that prove the fact that you paid for a past fight? How does that prove that you've contracted for a next fight? After the success of that fight, we were proud of our mutual efforts and assumed, okay, you and your team would have been elated with the results Triller was able to deliver. We were sure it wouldn't even be a question regarding our partnership for the next event per our contract. Oh, there's the word contract. There's the word contract. But there's no assuming if it's written in a contract. Like if it's written in a contract, you don't need to assume it's not a problem. It's in the contract. I mean, maybe that's the assumption. The assumption is we assumed you didn't have a problem with this contract because we have a, contract. As we worked to plan the event, Triller and I tried to reach you multiple times, but every time we reached out, your team told us that you had no interest in speaking to us or in moving forward with the event, much to our surprise and confusion. They are also confusion. Does Triller think they had a 3-fight deal? Because it sounds like they thought they had a 3-fight deal. That's what it sounds like. Triller spent over $30 million. Yeah, okay. Are they trying to guilt him? Like, what's with the amount of money? We spent this much. We spent that much. Old. What's new? Unless it was we spent $30 million for a 3-fight deal, saying we spent this much with you in the past is irrelevant. It's just irrelevant to whether there's a new contract or the contract for 3 fights. It feels like they're trying to guilt him into, but look how much money we paid you. Why aren't you acting more grateful? And my interpretation, that's how it feels. That's how this reads. This doesn't read like a cease and desist or like a demand of performance or specific performance, which would be like, by the way, remember on this day and time when you signed this thing and we've performed and you're not performing? We demand that you perform or you're in breach. And if you're in breach, we're going to have to sue you. And we don't want to do that. So please don't be in breach. Let's just all work this out together. That's not how this reads. This reads, be grateful. Triller spent over $30 million on your fight against Roy Jones Jr. It doesn't doesn't say that that's how much he got paid. It said that's how much they spent. More than 25 million of that was paid to Frontline, Legends Only League, and your affiliates. Oh, that's how much. Yeah. Yep. There it is. Next line. I haven't read this yet, so that's why it all seems new to me. You're like, this seems new to you, Emily. Yep. It does seem new to me. I'm gonna have to change the title of the video and be like, oh, we talked about Triller again. I didn't think we would talk about it this much. We are unaware of your agreement with your other partners in Legends Only or Frontline, however, and we ask if perhaps somehow you weren't made aware of the money paid into your entity. It sounds to me like they have reason to believe or are responding to a statement that he said he didn't get paid. It sounds like they're saying, but no, we paid you. And I'm wondering if that's what is going on, if there's other statements from Tyson being like, I don't work with them, they didn't pay me, and they're trying to clarify it. That would make a whole lot more sense if Tyson was saying he wasn't getting paid. We'll get back to the story in a minute and see if we can clarify. Still under the weather, by the way. Sorry about that. We are told that these companies were representative of your interests and that all of this money was being paid to you. Hearing about some recent comments you've made to people in the boxing world. Wait, is this letter based on hearsay? We heard that you said to so-and-so that you were unhappy and we're trying to... What? What? Based on statements to somebody else. Hearing about some recent comments you've made to people in the boxing world, I am starting to suspect that you received only a fraction of the 25 million we sent to you. I've heard from multiple sources that you have been made to believe that we did not pay you in full and that you believe you have taken legal action against us. Well, no, that's not a you believe. But it either is or it isn't. You believe. I've heard from multiple sources that you have been made to believe that we did not pay you in full and that you believe you have taken legal action against us. That's a you did or you didn't. There's a lawsuit or there isn't. What? What? Okay. We're going to have to go searching to see if Tyson has sued Triller. We're going to go digging through Triller lawsuits for Friday. I can say with certainty both of these claims are false. Oh, maybe they're not sued. As far as payment, I've attached bank letters that confirm that all $25 million were paid to Frontline prior to your fight with Roy Jones Jr. As far as the claim that you have pending legal action against Triller, that's outright false. Unfortunately, we have no choice but to take legal action against you, which has been pending due to the events after the fight. Recently, your team reached out hoping to settle the pending suit we have filed against them/you, a suit that Triller took no pleasure in filing. Hopefully, it's written better than the other Triller lawsuits, because otherwise I can see why they took no pleasure in filing them. But became unavoidable after your team attempted to move forward on another fight in violation of our agreement and rights. It is unquestionable we have a contractual right to your next fight, including but not limited to with Evander. Having spent over $30 million on your first fight while being told it was a crazy risk, be thankful, no one would take was only because and for this right to a Tyson Holyfield fight. We have also entered into an agreement directly with Evander. My team and I have nothing but the utmost respect for you. Be grateful. Instead of turning this into a legal battle, one that would indefinitely hold up your right to fight, we would love to sit down, resolve this, and get you in the ring with Evander. All we have asked is to remove the middlemen and have a one-to-one conversation. I mean, that's not an unreasonable question. Like, could we just bring the lawyers and the people to the table and have a chat? We are confident together the truth will prevail. This sounds like a whole lot of hearsay. Like we hear like, yo, here's what it is. Like, so-and-so said that they heard from you that you don't think that you got paid, but we think that you got paid. Like, what a mess. What a mess with like multiple layers of hearsay. Multiple layers of hearsay. What an absolute mess. Call it Tyson versus Triller 1. Well, Triller definitely is no stranger to the lawsuits. For Friday, we'll dig in to see what Triller lawsuits there are. Kavanaugh says they haven't been sued by Tyson. Like, are the people around him just not telling him what's going on? It's wild to me that it's like, oh, by the way, I don't think I got paid. And they're like, no, what we did was pay you. Because that seems like a much bigger issue. If $25 million is missing, I'd be fucking pissed too. Let's see what Boxing News has to say about all of this. Mike Tyson is being sued by Triller for refusal to work with the company. Triller claims the company paid him $25 to face Evander Holyfield. Triller seeks to make sure Tyson won't stage events without the company's involvement. So they're seeking specific performance. Like, hey, we have a contract, do the thing. This has so many ads on it. I don't even think I can pull this up. It has so many ads on it. I think that's what's crashing this. Let's see if there's anything new in this article. Kavanaugh also bared the reason behind the lawsuit was to prevent Mike from staging another exhibition fight that did not involve Triller. So they're going to be asking for an injunction, I imagine. And we'll pull the lawsuit. It looks like it got filed yesterday. Let's see if we can find it real quick. I think this website is causing a lot of problems. So we're going to we're just going to get rid of that website. And look, everything cleared up. That was the one that was lagging things. Let's see if we can find it real quick. Maybe. Let's just look real fast. We're gonna piece our search together, y'all. I'm very curious to see if the same law firm, really just because I want to see if the same law firm filed it, truly. Triller Fight Club 2 LLC. I wonder if it's under a different company. Let's see if we can just do a quick, the things I normally do when I prep. Oh, there's a bunch of Triller Fight Club cases. Okay, let's take a look real fast. Triller Fight Club versus Brandon Williams versus Canada Inc. versus Space Inc. versus Santos versus Swords. None of these are all different cases, I think, arising. Here, look. These, I think, are all different cases arising out of the stream. These are the two that I've saved with the H3 podcast, but these are the others that were filed May 27th and then in June. None of these were filed yesterday. So let's see if I search under what company were they saying Mike Tyson was using. Legends Only League. Let's see if Legends Only League is who got sued. Sometimes these are a little hard to find the day or two after they got served or the day after they got filed. And it's hard to know sometimes the corporate names of stuff. Let's see if Legends Only League helps. No results. What was the other company? Let's just search and see if they sued him personally too. Let's see what comes up under Mike Tyson. Oh, a whole bunch of stuff. I mean, that's not unusual. I shouldn't have said it that way. That's not unusual. We're going to look for filing date and see if we can find it. Descending. Because stuff happens. No, these are 2019. I don't see anything newer than 2019 under Mike Tyson as an individual. All right. We'll search for these for Friday. I'll see if I can find it before then. And share it. I'm sure it will start coming up. Yeah, I'm sure it will start coming up now that it's hit the news. And we'll find the case number. Nope. All right. I'm sure it'll come up in the coming days. What else were we going to pull up on Pacer? Oh, we were going to see if they're... Oh, I forgot. There was one other thing I was going to do that I didn't do, because on Friday we talked about Erika Girardi. So let's talk about Erika Girardi real quick, and then we're going to get to questions. Let's talk about Erika Girardi real quick. Girardi. I talked about Erika Girardi's lawyers filing a motion for the court to reconsider the appointment of Ron Richards, but I had not searched to see if Richard had responded to the media, because I just assumed the response would be an illegal filing. My bad. I should have absolutely searched to see if there was a response. I'm going to try to pull up, while I'm talking about this, I'm going to pull up Pacer to see if there's any responses there too. But I was interested to see what the response was, and there was a response to page 6, and there have been others. So I'm going to pull up the response because, again, it is only fair to pull up both sides of a statement, and there has been a response. Let's see. The hearing is set. So let's pull that up. We're just going to pull up the docket together and take a look. No, this is old. Ugh. I did it the wrong way. Where is the order? Where is the hearing date? Order granting stipulation to extend briefing schedule on motion for reconsideration. What? Good Lord. I tried to make it big so everybody can read it, and then I made it a problem. Let's see. Stipulation by Erika Girardi, filed interested party to extend the briefing schedule on the motion for reconsideration. So when did you extend it to? So that means they have a longer time to brief it. Let's just take a look at the documents real quick. As we're just going to do it live. We're going to pull it up. Let's see what they propose the briefing schedule to be. I'll download these in a minute. The deadline for an opposition to the motion shall be extended to Friday, July 2nd, or to honor before 4 p.m. Friday, July 16th. The deadline for any reply to the opposition to the motion shall be extended from Friday, July 9th to Friday, July 23rd. No further pleadings will be allowed. So we're going to see the trustee respond by Friday, July 16th, which over the 4th of July holiday is completely fair and not unusual. Like, there's nothing weird about that. It's just, hey, this is supposed to be due July 2nd. We need a little bit more time. And then the response will be due July 23rd. So we won't see a hearing on this until a number of days after that response is due. And the court will set a hearing to that after that time. The court has signed this proposed order. So we won't see a motion on that until from the bankruptcy trustee until July 16th. Nothing weird about that at all. So we're going to just go to what was said to page 6, because that's what we've got. And again, only fair to cover both sides. So exclusive details from page 6. Erika Jane, they say, is fighting to have a lawyer booted from her estranged husband's bankruptcy case after an attorney filed documents alleging she wasn't cooperating with investigators in the investigation. In the new documents obtained by page 6, well, obtained by everyone. We all have them. Lawyers asserting that the Real Housewives of Beverly Hills star has been and remains willing to fully cooperate with the investigation and demands that lawyer Ron Richards be removed from the case for making false and inflammatory social media posts and public statements. Jane is not a media fiction. She's a real girl with rights, including the right to be treated fairly. That I make fun, but actually true. She has a right to a trial, and a right to a trial comes with limits on pretrial publicity and what you can say about the opposing side. We talked about that on Friday. They allege that Richards continues to harass her publicly through extrajudicial statements. Say that 10 times fast. Including social media to his over 16,000 followers on Twitter. He was engaging in YouTube interviews that harmed the case. What up and Adam? Who was the YouTube channel that the YouTube interview was pointed out in the lawsuit about. Jane included screenshots of his social media activity. There was a lot. Go to the timestamp on Friday. We covered it in full. It was a lot. Richards told Page 6 in a statement Friday. I wonder if this was published like while we were talking about it live, because, well, no, I didn't search for it before. I should have, but I didn't even imagine there would be a statement to Page 6. I just imagined we would wait till the next filing, but Richards told Page 6 in a statement on Friday, not a single professional of Erika's has cooperated with our office regarding the Girardi Keys estate. We have filed numerous motions seeking documents and communications. This motion is designed to slow down our work. The Thomas Girardi estate is moving for relief from stay to pursue her in state court. This does not look like cooperation. We will talk about that on Friday. He added, it is laughable to suggest that our 1,600 followers compared to Erika's 417,000 followers in a city of 12.5 million would somehow have an impact on anything. I don't think that's the metric the court uses, though. The court's not like, yeah, but who has a bigger following? That's not how the rules are written at this point. The First Amendment does not leave itself in the doorway of the courthouse, and the motion is a transparent attempt to interfere with the trustee's choice of counsel. These First Amendment arguments were previously raised by her other counsel and rejected. No gag order was issued. Yeah, but then you were appointed and the statements are different. But okay. Simply submitting innocuous and inadmissible hearsay comments on publicity-filled documents does not create any relevant, actionable information. Well, we'll see. This week in documents filed by Richards, Jane was accused of refusing to turn over her bank records to the bankruptcy trustee and using her glam lifestyle to conceal assets in the case. I mean, yes, it accurately summarizes those. So that's the statement made to Page 6. I posted it on Twitter for you guys to read. We'll see what the trustee says they are going to be arguing. And I think we are getting into a new realm of the role social media plays for lawyers, because there is a balance about what you can say when you are the attorney on the case, different than what you can say as a commentator. And that is something the court is going to have to balance. And the balance will be very interesting to me. Let's get into questions. I'm going to pull up and see if there's any new documents filed in the Britney case, but it's going to be very interesting to see how the court starts to address these things. And these are things that the court is going to have to continue to address, because when these rules of professional conduct were written, and they do keep getting revisited, but when they were written, Twitter wasn't like a thing. It was traditional media interviews and stuff. So this is different. So let's just get to I have questions. We'll get to court of public opinion ruling in a little bit. And then I have a little bit of an earlier out today because I have some stuff to record that I can't talk about yet, but I will share with you later. I feel like such a YouTuber saying that. It's like, well, I can't talk about the thing. There's a reason the hair's done. We'll talk about it later. All right. I have questions. I have questions. You have questions. We all have questions. Let me start answering those while I start looking for Britney. We're going to do stuff. Lyle Rose, can't get over it. Your hair is so pretty. Thank you. The miraculous and wonderful Garland came over this morning and did the hair because I have some other things I need to film today. And so we did hair. Well, I didn't do hair. He did hair because he's amazing and is much more skilled at this than I am. So I had help. I absolutely had help. We had help today. Thank you all. We'll take a minute. I'll show you the hair. We did. And there's he put pink under it, so you get the little differentiation in color. I am very happy with it. So how long is your hair? I don't know. It's curled, but it's down to here when it's not curled. All right, let's get to some questions and pull up Britney stuff. Kathy says, if it is proven that Erika's gifts were bought with illegally obtained money, wouldn't that make them seizable like stolen items? Kathy, that's a great question. I'm going to get into that in just 1 second. Y'all, I have not asked you to do the YouTube things. There's 2,500 of you here. Can you do the YouTube things? Why are you in my yard? Where are you going? Somebody is just walking through my yard into the forest behind my yard, which is a very strange thing to do. Okay, go off. So do the YouTube things, the likey things, the subscribey things, all the things, and double check it, because you know what? YouTube keeps helpfully unsubscribing people, and that's annoying. Really annoying, but it happens. So do the YouTube things, the likey, subscribey things. In the Girardi case, there are two bankruptcies. Tom Girardi as a person and Girardi Keys, a law firm. The gifts are an aspect of the Tom Girardi as a person lawsuit. So they are whether or not this is community property that needs to go into the bankruptcy. And that is being fought over. Boris Trazon, I hope I pronounced that properly, is the attorney that has been appointed as the special litigator by the bankruptcy trustee, Jason Rund, in that bankruptcy. And that attorney is going after those items. I'm trying to find my slippers under here because the air conditioning is making my feet cold. Like, I don't want to be sweaty, but now my feet are cold. It is. I also got my nails done. I'll show you those too. So the argument in California is that there are exceptions for gifts in marital property. So tracking down where this money came from is going to be interesting, but there is no asset forfeiture per se. This is not a criminal proceeding. There is not a civil asset forfeiture. It's a bankruptcy. So they are going to fight over whether these assets are properly marital or community property, or whether they are not community property under the rules. That said, I could see Erika fighting this with regard to the personal side of the bankruptcy if she believes that she is going to have to pay on the other side of the bankruptcy. She's still a debtor, so she might win the right to keep these assets and then have to sell them to pay off debts anyway. So this might end up being a wash. I don't know if it would be worth the legal fees to fight over these, or to say, you know what, you're right, they aren't separate property, sell them into the bankruptcy estate, because she's going to be left holding the bag on some of these debts anyway. And that's going to be a very, very interesting thing to see how this breaks out. But it's not a forfeiture per se, because we're not in that kind of proceeding. It's going to be a mess trying to sort out what's gifts and what's not under the California law, because there is room that gifts can be separate property in some instances. But I am definitely not a family law expert by any means. So, question, will Britney's case impact other conservatorship cases? I think it has brought a lot of questions about conservatorships to the forefront. I think groups that have been fighting for reform within conservatorship has a great example that everyone understands now. Where are we going? Oh, you're coming under here. Okay. I think it gives a good example to say, look at the things that can happen inside conservatorships, and gives groups that are advocating for rights, that people shouldn't just have their rights taken away, that there should be levels, or there should be phasing within this, that I think her case has gotten so many headlines, it brings the spotlight onto what reforms are needed. So I think it can impact other cases in a positive way when reforms are needed. And I also think it gives advocacy groups the right to say, look, this is what's happening to somebody who's famous and has money. Let's talk about what happens to the cases that the public never looks into and that people never see. Let's talk about what goes on in the system. I also think it'd be easier for people to get the ear of their local Congress, local senators, to be able to advocate and actually have someone listen, where before this came to light with Britney, it might not be so on the mind of politicians. And look, when you get politicians onto something that they can use to take to their constituents and be like, look, I'm doing something, it helps if that thing's in the news, because it actually will get press coverage and will allow the politicians to do, you know, the political things they want to do, which is say, look at what I'm doing for my people, get me reelected, which is just the way that it is, I have to enter this case number in like 17,000 times to get this to pull up. I'm trying to make sure, I'm trying to see if there were any new filings in the Britney case, and there are not any new filings in the Britney case, nothing since 6/25. Any news on the Chicago cases? The Girardi Chicago cases are mostly stayed. There was stuff going on. We have both paw nerds hanging out back there. What are you doing, George? You just getting in there? All right, do it, buddy. The paw nerds are like, it's nap time. Yep, they've just taken over that chair, haven't they? So with the Chicago cases, and I have not peeked in on them in a while, they were mostly stayed, but there was stuff going on with the other attorneys and trying to figure out what the other attorneys knew. The other attorneys were objecting to depositions and stuff. So I'll have to go back and look and see how the discovery fight in that case is going for sure. Oh, nope, I totally moved my camera. I didn't mean to move my camera. I just, me. I meant to move me so that you could see the cats. Because I got like all to the side. My desk is a mess. My husband attended like a webinar this weekend, and shit just got moved. I'm gonna have to sit here and move stuff back, but stuff just got moved. Like when somebody else is in your car and they move your car seat, that's exactly what's happening at my desk right now. But I want you guys to be able to see the cats behind me, and I had gotten all moved. So let's keep going for questions. So many questions. I got way behind on questions. Sorry. Question, is this your warm-up for other filming today? No, it's definitely not my warm-up. I mean, we do coffee and Cursey words every single Tuesday. It's just the first thing that I'm filming in the long day of filming, but I got to get this taken care of. Garland is my glam squad. He definitely took care of the hair. I do my own makeup. I don't think I will always do my own makeup, but I don't do makeup well. I try. Like, this is what we got. This is it. Today we're wearing Shimmer of Hope from Girardi Cosmetics. I very much like it. It doesn't get sticky when I talk, which is critical for filming. General question, why is battery called assault so often? I thought assault was me screaming in your face threateningly, and battery was when I touch you. Assault and battery do have different definitions, but a lot of state laws and state criminal laws have conflated assault and battery together. So a lot of assaultive type crimes would actually fall into battery crimes because battery is a touching. But I'm going to pull up for everyone the legal definition, and I am going to use the computer legal definition because it is different. And this is coming up now as Gabby Hanna is trying to relitigate like the entire internet, but what happened with the rice gum situation. So if you knock somebody's property out of their hand and don't touch them, that can still be an assault. It can also still be a battery, but assault and battery generally go hand in hand. So under Black's Law Dictionary, assault is any willful attempt or threat to inflict injury upon the person of another when coupled with an apparent present ability to do so, and any intentional display of force such as would give the victim reason to feel or fear or expect immediate bodily harm. So an assault is like the steps before the physical touching being the battery. But why? Because state law has conflated the two into assault and battery being kind of almost one thing. But yes, an assault would be the steps before the battery. Normally they go hand in hand. Mother Oats, I always read it. I always read your handle wrong in my brain, and sometimes it takes me a minute. Can Britney hire her own doctors through her attorney? No, she cannot. Britney does not have the right to make medical decisions on her own behalf because that is a very explicit power of the conservator of the person. So she cannot change doctors, fire doctors, have her IUD removed. That is all the medical decisions are made by the conservator of the person. It's like having a medical power of attorney. You don't get to make the decision. And it sounds crass because Britney is clearly aware and and fighting to be heard, but she's being treated the same way as somebody with a medical power of attorney is treated, but in a more severe way. They don't make the medical decisions. The person with that legal power makes the decision. So they've taken Britney's legal power to hire her doctors and given it to the conservator of the person. That is the person who has the legal rights over her. She does not have the legal rights over herself. So, yep. which is hard, right? It's just crazy. It's just crazy. So thank you. I know the hair is down and you definitely get more of the color when it is down, don't you? We could definitely do more likes than that. I appreciate you. I follow my favorite murders rule. Don't go into the woods. Yeah, never go into the woods. Like never, ever go into the woods. I was very confused as to why people were just trying to tromp into the woods. I did not pump up the purple again recently. It's just my hair has been back because I have been sick. So that is part of it. Question, where is Keese in all of this? Melissa B, great question. So Keese is one of the original creditors in the Erika Jane Girardi stuff. Keese of Girardi Keese retired ages ago and was supposed to be paid out earnings that he had earned on lawsuits and was not getting paid. He was also part of a ownership interest in the building and he wasn't getting paid on that. And he sued twice in December. I broke those lawsuits down ages ago because December. Ages ago because December. He sued over the property trust and over the money, like essentially his retirement fund that he was supposed to be getting. And what had happened was he had left Girardi Keese and retired, and he was supposed to be getting a monthly payment of a certain amount, a substantial amount to my memory, but a certain amount because the cases he had worked on were still getting paid out. And that was essentially going to be his retirement. And then he stopped getting paid. So it looks like Keese might be out his retirement as well in all of this and is one of the original creditors that pushed this into bankruptcy. And it sucks because he probably trusted his partner to be like, no, this money's coming in. I'm going to pay you monthly. And then the payment stopped. And it's like, wait a second. I worked my entire career to have this amount of money. And now it's just, what? It's so wild. It's so wild to me. So Keese is one of the creditors trying to get the money he's owed back for both the building and for his retirement. Hello, Brie Patrick. Good to see you. Question, does Britney being in a relationship contradict being the subject of a conservatorship? I don't follow the logic of having an intimate relationship, but also legally not having permission to consent. It is a tough one to wrap your head around, and it is somewhat of a legal fiction, right? Because technically she does not have, or is said to not have, that ability to consent because she can't hire her own lawyers. She can't sign contracts. She can't enter into those agreements. But the conservators have allowed her to have a relationship, and the conservator of the person has clearly allowed or had those conversations to have her in a relationship. So that would be under their care plan. And it is a strange legal working, but I'm glad Britney's in a relationship and has a relationship that she hopefully feels is supportive. Because can you imagine just being just so isolated? The whole thing makes me so sad. It really, really just makes me so sad. Welcome, replay crew, still here while it's live. Come join the Q&A and then go back and watch. Let me try to get to everything jumped. I see some super chats. We're going to get to those next, and then we'll keep going. Question, you mentioned in a previous video that your tinted glasses help with your ADHD dyslexia. What's the science behind that? CV, I go through Erland.com and they have a ton of information about Erland syndrome. It does not help everyone. It does not factor into everyone. I have found it to be significantly helpful for me and my family based on the way I process stuff. But IRLEN.com will have a ton more information on the tinted lenses and how they help. They don't just help for ADHD and dyslexia, but they can also help for other processing issues by filtering the spectrums of light that come into your eyes. So that is all on that website, done by people much smarter than me. When you notice like a lot of, not all, but a lot of musicians who wear tinted lenses on stage, a lot of that's to filter out light so that they maintain their energy, which is interesting. Question: if Britney moved to Nashville, would the conservatorship be valid? I don't know every state they've extended it to. I know they've extended it to Hawaii and Louisiana because I read that and noted it specifically because that's where she's allowed to travel to. I imagine they extended it to Nevada because she was performing in Vegas for so long, but I don't know where else they've extended it to. That doesn't mean that they couldn't easily extend the conservatorship papers to a different state and have that done pretty easily. But could it be that she could move to another state and that state could be like, we don't find this valid? I mean, I think it would be tough because her money would still be tied up in California. Like, could Britney run away? I don't know how that would practically work. Family law legal assistant. Hello, Samantha. Worked a case where we were trying to determine if the private jet given on Valentine's Day was a gift or a marital asset to be sold. Yeah, those are next level rich people problems. And in California, it's very interesting how gifts work and the money and the room for negotiation and discussion over it. And the law is not super clear on those things, and they go very case by case. So it is a thing. Ashley Vincent, thank you for the catnip tip. The paw nerds are spotted there. Just huckled up, aren't they, Fred and George? I want them to always get the good stuff. They do get the good stuff, and they are both just asleep. Let's see if I can focus here. Let's take a minute and focus in on the paw nerds. We're gonna move the focus from me to them real quick. Let's see. Move my head. Move your head. Move your head, Emily. Let's see. Can you guys see them back there? They are just cuddled right up. George is right there. Fred is right there. And they are just, I don't think I can make that any sharper based on the length of this prime lens, but there they are. Paw nerd cam. Watch me not get myself back in focus. All right, that looks good enough. Question: in Britney's case, can flights be considered a living expense when it's not Britney's flying, but her family members? Because there are many flights paid by Britney for her sister and mother. I don't know. It would depend on how it's lined out to the court and what the purpose is and how it's lined out to the court under that. Sometimes, yes. Question: is there a way to support Britney without money going to her dad? I mean, all the money goes into the conservatorship. So the ways to support her, one, I think, are to, I mean, I don't think she has access to, I don't know if she has access to her social media. I personally have deep questions about whether she is allowed to be on her social and how much she sees. I imagine Sam can tell her what's on her social, but I also worry that Sam has to toe the line so he's not isolated from her. But showing support publicly, showing support on her posts, I think is one of the ways she can see support. But anything supporting her music or anything is going to go through the estate. But eventually she's going to need that money if she hires her own attorney. So I don't know the right answer. I think it's a personal, how to best support Britney has to be a personal choice. And I still stream her music. I understand that money is going to be dealt with by the conservatorship first, but also it's her money. And I hope that as she's able to take control of her money again, which she has asked for, that it will be there for her. Question: if the conservatorship was granted based on allegedly false statements regarding Britney having dementia, could that be a case for prosecution? That's a lot of it depends. Without having the court documents, it's hard to say what the court was basing stuff off of. The court can base the conservatorship off of the documents I showed on Friday, which don't take a lot. Can the court question that? Yes, but this has gone on 13 years. If there seems to be fraud in this thing, is that something that should be explored? Absolutely. How that would shake out, I mean, anything's possible. I think the statutes for false imprisonment in California would be a hard fit with a conservatorship because it's legally granted by the court. I think fraud might be a little bit easier, and like theft by duress and kind of the theft by fraud cases might be a little bit easier, but under the false imprisonment statute, I think that would be hard. So you didn't miss the Jamie Lynn discussion. I didn't really discuss Jamie Lynn. I don't know what to say about Jamie Lynn. She made statements on social media about her sister. Her sister said her whole family hasn't been behind her. I mean, that is, I try to stick to the court stuff and not the family stuff because there's so much there. Ada said, question, Britney's case is unusual because their conservatorships are usually for people with dementia or Alzheimer's. So most conservatorships do end if somebody passes. That's how a lot of them end. They do tend to be for things like Alzheimer's and dementia, but they can also be for other adults, and not always older adults with significant impairment. And they don't always have to be both a conservatorship of the person and a conservatorship of the estate, depending on what the needs of the person. Conservatorships should be the least restrictive means necessary to protect the conservatee. I think the biggest question here is that it doesn't seem to be that that's what's happening for Britney, and that's part of the problem. Question, do you know the length of the standard conservatorship? Is Britney's within? Well, Marissa, most of them are for the life of the conservatee. We just kind of touch on that. The questions work so nicely together. They're normally for the life of the conservatee. It's rare that people get out of conservatorships because normally the thing that caused you to need one remains a present and constant factor. So if you look at a somehow incapacitated young adult, 18, turning now 19, 20, 21, where they still need to be cared for financially or medically by a parent, that would go on the rest of their life because that need is not likely to change. It's unusual that the need would change, but that also isn't impossible if the stress that Britney was under made her so vulnerable to external fraud and so unable to deal. This could have been something that was a temporary need, but the conservatorship papers have been extended every year for the last 13 years. So, yes. Haley was like, wait, how do you reconcile harassment versus assault versus battery? It depends on the fact scenario and the state laws. Harassment laws can be both criminal and civil. Assault and battery can be both criminal and civil. Some states call all the misdemeanor things assault, even though sometimes they're an assault and sometimes they're a battery. So the way they're referred to in the media and by the population in general tends to go to what each state calls it. But some states do have misdemeanor assault laws and misdemeanor battery laws that are separate. And that's where the job of a district attorney generally comes in, is deciding which law applies to the facts and then breaking down the facts. Question, can what Triller is doing considered harassment? I mean, they filed a lawsuit. So generally, no, that would be covered by litigation stuff. Could you say that filing a lawsuit is harassing? I mean, it'd be really hard, especially if there seems to be a contractual dispute and they're trying to make him specifically perform. So, I mean, releasing the statement on social media, I don't think so. I mean, unless they've done more than just what we've talked about today. Question, are there paparazzi specific laws? In some states, yes. Or do they fall under journalistic freedom? In some states, yes. Paparazzi are so invasive. They can be. There are paparazzi laws. California, hold on. I forget the name of the statute. But California passed paparazzi laws and other states passed them too. And other countries have them differently. Let's see when these came into play. This is an article from, if you don't date your article at the top, it makes it really hard. I have no idea what the date on this article is. This is a date about Hawaii, looking at Senate Bill 465, dubbed the Stephen Tyler Act, the legislation that was enacted in California. Many of the laws have been centered in California, where in 1999, the state first passed an invasion of privacy statute directed specifically at paparazzi activity. Hawaii is passing something that's similar and comes in the wake of several high-profile confrontations involving Justin Bieber, Chris Brown, and just as California Appellate Court prepares to evaluate the constitutionality of the recently written photography law in the state's vehicle code. So there are vehicle codes again. Let's see. But yes, there are states that have it. I have not pulled up the 1999 paparazzi statute, but there are a bunch of different facets of that, because it's like the taking photos of a driving vehicle, taking photos while you're driving, the invasion of privacy, some of the stuff are involving telephoto lenses on private property. This goes on to say in 1999, California enacted an invasion of privacy statute directed specifically at paparazzi activity. The anti-paparazzi statute, California Civil Code Section 178.8, has a broader reach in the activity, and it targets more than other state privacy laws. The California standard is stricter than traditional standard and privacy law, which protects individuals from actions that are highly offensive. The intent, the statute prohibits trespassing on another's property with the intent to capture any type of visual, image, sound recording, or other physical impression of a person engaged in a personal or family activity that would be offensive to a reasonable person, not highly offensive. So yes, there are anti-paparazzi laws. I haven't really gotten into what they are. These were after there was that paparazzi that crashed trying to get pictures of Justin Bieber. And that's why there are some of those motor vehicle laws as well. So, Marissa, we talked about that a bit, and it is definitely a question and a legal question. So it is, but speculating on what Britney is allowed to do with her boyfriend is rough for me, because I feel for her. I have not seen I Care a Lot. I've seen lots of comments in the comments about it. So what Fred is just like got his leg. What are you doing? He's just like, Fred is completely asleep. I have not seen it, but I will when I have a moment. I have been trying to keep up with the Housewivesies things. Ada says conservatorship is usually for dementia or Alzheimer's, so not seen one end could be. Yes, I think what you're saying is they generally don't end because they are in place until the person passes. Yes, true. Also, but they are in place for other things other than just dementia and Alzheimer's. So, and they are and can be in place for younger adults with disabilities that make them vulnerable. So, but the reason they don't end is, as I said before, generally those conditions or causes that make the conservatorship necessary don't change. Question: can Britney petition the court for evaluation by doctors not under the conservatorship rule? Most doctors shouldn't be under the conservatorship's rule, but the doctors are chosen by the conservators because Britney doesn't have really the ability to do that. It was really stunning when I was talking about the business manager, when she got a new business manager, and Britney's attorney, Sam Ingham, was filing papers saying, hey, you didn't even run it by us who the new business manager was. And Jamie Spears's attorneys were like, Britney doesn't have the right to know who her business managers are. Under the conservatorship, we make those choices. You really got a sense of how they see it. Like, she does not have the right to make that decision. And legally, that's correct. It just feels really awful. But could she petition for a different doctor? That would have to be dealt with the care plan with her conservator of the person. How would that come up? I mean, it would have to come up in discussions with her conservator of the person, Jody Montgomery, with her attorney. Whether that would be a petition to the court, I don't know if that would be the appropriate vehicle for that, because they are talking about modifying the care plan, and in modifying the care plan, modifying the doctors could come up in that. George, did you literally just sit on Fred? He did. He just moved and sat on his brother. Question unrelated, I know. No worries. How difficult is it to terminate parental rights if a parent has a history of abusing children and hasn't had contact with them for 3 years? Brandy, I appreciate the question, but that sounds like a very fact-specific and a very specific question that would need specific and particular legal advice with regard to the facts of the situation and an attorney that practices in that specific area, because I can't give specific factual legal advice that is of any help over the YouTubes, because there is so much that goes into it, and jurisdictions do matter. So an attorney in the specific jurisdiction that has all of the facts, things that a attorney would ask is, well, it depends. What type of abuse are we talking about? What type of contact? What does no contact really mean? Is it no physical contact? No contact by FaceTime? Like, there are a lot of questions that would go into answering that well and thoroughly. And that is a question for an attorney in the jurisdiction where there is a parenting order. And that hopefully helps. Thank you for the super chat. Almost surely. Question, does the conservatorship have to go to every medical banking appointment? Does the conservator? It depends on the care plan, whether Jody Montgomery goes to all of those appointments. So it just depends. Britney wouldn't be going to like banking and stuff appointments. Those would all be done by the conservator of the estate. She wouldn't have any part in that. The only parts she would have a part in are her appointments. Sometimes you will get just reports back to the conservator. It really depends on her care plan. What I got from her statement to the court was that the doctors were talking to her conservators behind the scenes, because she was complaining about that in court, saying, they're telling my doctor I'm not doing this, but that's not true. So she was frustrated with the communication. Did the Josh Duggar hearing get pushed back, or is it still in July? I have not looked for the next hearing date, but I can, because Pacer is still pulled up. So hold on, I'll tell you what the next hearing date is. We're just going to go ahead and tell you the next hearing date. I don't know if it got pushed back. I have not looked in on the Duggar case since the last protective order was issued with regard to the discovery being turned over. There is a response to the motion to continue trial, and that doesn't look like it has a court date to be heard for the motion to continue trial, but the feds filed their response to it, saying that trial is set for July 6th. So the court hasn't heard it yet. I imagine it's a little early for that to get pushed back. They're trying to push back trial from July 6, 2021. No, that's this year. That's soon. This will probably get granted. So the trial is set to start July 6, 2021 from the arraignment held April 30th. This will probably get granted. That's really soon. They need to do their forensics. So they haven't granted that yet, but the trial dates. My guess, and I don't normally put percentages on things. Normally, I do not speculate. I cannot imagine the court denying the motion to continue trial. So I don't see a next hearing date for it, but I imagine it will be soon, because the trial date is, in like a week. So that the trial's still set for July 6th. That's going to get pushed. I will be shocked. I will be shocked if it doesn't get pushed. I'm saying it's going to get pushed. Shocked if it doesn't get pushed. All right, guys, I'm going to answer a few more, and then we're going to get to court of public opinion, and then I am going to have to wrap up. I pulled this up and I lost the stuff. Interested in your gut reaction to Britney's sister Instagram live? It made me mad. I was literally like red in the face. I mean, I don't know what is true in a thing or what is not true in a thing. Sam Munoz Consulting. It's so good to see you, friend. I don't want to get involved with like the family stuff of it. I can't imagine how hard it is having your family go through the media, having people's perceptions being what they are based on what they see in the public and nothing else. And I don't have the full history of what Jamie Lynn has been up to or not up to during this conservatorship. I feel for this family. I don't really have a lot of empathy for James Spears, but this is all playing out in a very public way that has to be hard on Britney's siblings too. I don't, I, I don't know. I'm torn because it's a family matter that shouldn't all be public. And it's got to be hard if you're dealing with a sibling that is in this circumstance and you know things behind the scenes. And I get the sense that Jamie believes Britney needs to be in the conservatorship. To have to comment or be asked to comment about your sibling's mental health, I think would be very hard. And I don't know if there's much Jamie can do to get her sister out of this. I don't know all the ins and outs of that relationship. The whole thing makes me sad. So the whole thing makes me sad. Whether Britney should have had a conservator or not, it never should have been her father. And the court will generally lean to a parent in that, and they are still trying to get him removed. Question, how did Amanda Bynes, that's right, Bynes, get a tattoo on her face if she was in a conservatorship? I don't know if the face tattoo came during the conservatorship or before, or if she snuck out, or if she did it herself. I have no idea how that happened. So I have no idea how that happened. Question, what is typically supposed to happen with annuities once the law firm closes Girardi Keys? I don't know if they had any annuities, but there is a whole process for legally and properly wrapping up a law firm. And the bankruptcy courts are having to deal with that now. Question, is guardianship and financial guardianship the same as a conservatorship? Kim T, it depends on the jurisdiction. Sometimes the words are used interchangeably, but not always. But yes, sometimes the words are used interchangeably depending on the jurisdiction. So it would just depend. I hate to say it depends, but it really depends on where it is. But yes, it can be. Though sometimes guardianships are more like guardian ad litems, which is different than a conservatorship. Questions. Can you cover... I cannot read that name. I think it's the Reeg Black girl. I hope I pronounced that right. TikTok sovereign citizens literally tried to steal her house. And they were, wow, that's crazy. Chosen Life, will you DM me that on Twitter so I can look at it? Sovereign citizens do that. I had a case. I'll talk about it Friday. I had a case where a house got stolen. It was a fucking mess. Like, it was a fucking mess. It happens. And I think I've told part of that story here before about the house getting stolen, but it happens. It's a mess. But yeah, DM it to me and I'll take a look for sure. Or tag me in it I'm at the Emily D. Baker on TikTok. If you tag me in TikTok, I'll go look and see the videos and touch on it for sure. Sovereign citizens are wild. Also tag Natalie Lawyer Chick because she covers sovereign citizen shit all the time too. So tag us both. Question, what if in the Britney, I don't know what Torres, she gets sick overnight, something happens in Hawaii and she has to stay in the hospital, but is not Julia, I'm sorry. I don't understand the question. Her conservatorship extends in Hawaii. If something happened to her and she had to go to the doctor, they would call the conservator of the person to do the medical stuff. What happens if a conservator predeceases the conservatee? Is there a backup? They would generally appoint somebody new. It seems dicey to have one person totally in control. In Britney's case, excuse me. In Britney's case, sorry. Let's see if my throat's going to behave. In Britney's case, there's a conservator of the estate, and now there are co-conservators and of the person. If something happened, her lawyer would deal with it in court, and there would be emergency hearings and stuff. I use NordVPN. There should be a link down below. Reba, I have not talked about the Casey Anthony case here. There's a lot of jury there's a lot of jury mindset that plays into that. I know other people have covered it. I tend not to cover true crime just because of my background, but we can talk about jury verdicts and weird jury verdicts at some point in the future. Question, is there any recourse for judges' behavior? Yes, they get put up for re-election, and they often run unopposed. It seems the judge in this case didn't hold oversight hearings for at least 3 years, and the previous judge had several complaints. And in long conservatorships, there might not need to be oversight. I don't know if they are required to do it by law if none of the lawyers are asking for it. So it might not have been improper. It might just have been ill-advised. But yeah, judges go up for re-election and can be voted out. I mean, that's really the recourse. And complaints can be made and the Judicial Oversight Committee can look into it. So, Britney's sister, Jamie Lynn, is a trustee of the conservatorship. She is, I believe she was removed, but she had been the trustee of the estate if something happened to Britney, appointed by the conservatorship, but she's not formally involved in the conservatorship, to my knowledge at this point. Is it legal to force Britney to keep in her IUD? Yes. I know she can't make medical decisions, but it's almost on par with forced sterilization. Surely that isn't legal. Right. They're allowed to make medical decisions for her, and it's gross, and I hate it. But that is allowed to be made in the realm of medical decisions, includes birth control. Whether that part of her care plan needs to be reevaluated, I think Britney has clearly said she wants it reevaluated, but it's not illegal to do in this limited particular circumstance because of the conservatorship. So, yeah, I know. Could we have fought that conservatorship? No, we cannot. None of us have standing to fight it. Britney would have to have fought it, and Britney wasn't allowed. And I can go back and talk about the timing of Britney's attorney, the attorney that spoke in framing Britney Spears, literally coming down to the minute of trying to appeal the decision and trying to become her attorney. Back when this all started, Britney having her own representation would have helped. We've gotten very, very far away with the ship being out of the horse on this. But as a public, I think the Free Britney movement, my speculation, has allowed Britney to see that people believe her when she speaks in court and that she's not broken. And I think people struggling with any kind of mental health, I think there's a shame around that there shouldn't be, of this, like, Britney said it in court. Oh, well, why would they believe me? She has everything. She's Britney Spears. But that doesn't mean she doesn't struggle. And so I just, I think the Free Britney movement hopefully has allowed her to see that people aren't going to judge her the way that they did in 2007, 2008, and 2009. Because I'm not discounting, she had that experience. The public was horrible to her, and she was vilified. And that wasn't fair to do to her when she was struggling so much. But the public letting her know, look, we hear you, we see you, and what's being done to you is wrong. Hopefully she'll see that and be like, you're right. People do support me. So, AB, question, is power of attorney or conservatorship, they're two different things, but yes, like Britney is under enforceable anywhere. No, there can be jurisdictional issues. It depends on the language of the thing and where it's been extended to, because Britney's papers have been extended to other jurisdictions so she can travel there. Yeah, the cats are totally having a full grooming session, and now they're just hugging. So they're just all cuddled up together. They do that all the time. They look like a cinnamon bun most of the time. Question off topic. Hannah, we're here for Q&A for a few more minutes, and I'm going to just do a couple more, and then I'm going to do court of public opinion, and then we will be out today. At least the stream is working properly. We had so many troubles at the beginning. Off topic about the Chauvin sentencing. What bearing, if any, does the Chauvin sentencing have on the 3 other officers' trials? None. Does it set any kind of precedent for Kim Potter? I don't know, because the Minnesota had another officer that was sentenced, different circumstances. I talked about it on the podcast, and was sentenced to 12. The upward departures in the Chauvin case are very specific to the facts of this case and the behavior of Derek Chauvin himself. The aiding and abetting, the sentencing doesn't really impact that. I think the fact that he was convicted and people know he was convicted means that the jury will, they're going to have to disregard most of it, but it's known that they were aiding and abetting a crime. He's been convicted of this crime. So the prosecutors will be able to say these officers were aiding and abetting this crime, and this crime happened. A jury found that this crime happened. So will the sentencing have much bearing? No, those go case by case, as they should. It'll be interesting to see what happens with the Kim Potter case, but those are all so fact specific based on the specific incident. So yes. Did I just ding Robbie? No, we dinged. I don't know when we dinged to 136, but it was not while we were on stream. I don't know if we're close. We should be close. If you guys aren't subscribed, go ahead and subscribe. We should be close. Let me take a look real quick. I can't pull things up. And my nose is, we're kind of close to dinging. We'll probably ding in between streams. And we'll probably ding in between streams. So thank you for the hair. Aren't there laws against forced sterilization, Angela? The thing is, conservatorships are very specific. And so things that you would think cannot happen can happen within the conservatorship. Also, it's the deep questions of women's rights and a woman's right to autonomy and bodily autonomy and what's right within a conservatorship are very deep and nuanced conversations. And for me, some of it really feels invasive to get into. The conservatorship's allowed to make medical decisions. This is a medical decision that they've made. Britney is asking for them to undo it. I hope there's a new care plan, and she's heard as a part of that care plan that takes her and what she wants into account. Her will should not just be put aside in this, but I also don't know everything. So obviously, none of us do. None of us have all of it. What's the significance of Britney's conservatorship being voluntary? Well, she's allowed to ask for it to end. But, conservatorships, the voluntary thing is just like, well, we went along and we didn't kick and fuss. I feel like it's hard to say it's a voluntary conservatorship. We've seen how Britney feels about it. But yes, technically it's a voluntary conservatorship, and Britney's never asked for it to terminate legally and formally. We're waiting for her attorney to do that. Question, can the years of therapy Britney has had be accounted for anything in her case? Do they take that into consideration? Not really, because it's part of her care plan. So it's just part of her day-to-day and what is medically deemed necessary for her under her care plan. But it's not like, it's not like she gets time for good behavior in a conservatorship. Hopefully her behavior is something that will be taken care of. And that's not what I meant to say. Hopefully her behavior will be taken into consideration, and her work to stay on a care plan that's necessary or not will be taken into consideration when she has to prove whether or not she is capable of being without the conservatorship and saying, look, I go to these appointments, I do this, I don't need this. And we'll see, for sure. So I'm going to do 2 more questions, and then we are going to go to court of public opinion. Question, do the therapists need to report to the courts? It depends on if reporting is necessary or if there's no need to change, and that would depend on the lawyers. Would there be improvements or a therapist change? A therapist did change because one of her therapists died, but if the conservator doesn't need to go into court on that, they might not necessarily go into court on that. But yes, it seems like there may be, I have questions about why there hasn't been that we've seen. It doesn't mean there haven't been reports. Those all would have been sealed. Question, it seems that Britney might not have been adequately informed of her rights. What happens if that is accurate and she was not given information of her rights? Not a whole lot, because she doesn't get to make a lot of those decisions, unfortunately. Whether she could make complaints down the road just depends on what those conversations were behind the scenes. And it's really hard to say. It's hard to put yourself in the shoes of that attorney-client relationship. So, thank you, Dana. Appreciate it. Hello, Missy. Marissa says it's really tragic that a child has more legal rights than Britney. It is tragic. It is tragic. And it is heartbreaking. There is so much we don't know that it's hard to give more detail because we just don't know. I will always reiterate, a conservatorship is supposed to be the least restrictive means. After what Britney has said, it doesn't feel like this is the least restrictive means for her. She clearly doesn't believe it is. I hope that the court will take that into consideration when the next care plan is presented, when her attorney presents motion to get Jamie off of the conservatorship of the estate. Remember, the court denied it. They tried to get Jamie off of the conservatorship of the money shit, and the court denied it. So we will see. Don't forget to like and subscribe. Let's look at court of public opinion real quick. And then we're going to go. Emily's got some other stuff to film, and we are going to go. I am seeing stuff on Twitter. Thank you guys for tagging me in the stuff that we just talked about. I just saw Britney stuff. Hold on. Let me see. Sorry, we're going to Twitter. Britney's testimony in court has been removed from YouTube after garnering 3 million views and over 10,000 comments due to a copyright claim by the Superior Court of California. Well, we knew that was coming for sure. I saw something else. I wonder if that was it. We knew that was coming. We knew that was going to get taken down. Hopefully, if you haven't seen it, watch it. I believe that it's been re-uploaded in a lot of people's videos. So we'll see. Oh, here we go. Free Britney Live. Hold on. I like this Twitter account quite a lot. So this is coming from Aphrodite said, X is coming forward like I've been saying in my readings for the past few months. We love Aphrodite. Free Britney Live exclusive statement from Britney's first husband, Jason Alexander. Let's see what Jason Alexander has to say. Hold on. I got to blow my nose for this. I'm going to leave it on the screen. All right, Jason Alexander. I was forced to sign an NDA, but cannot in good faith stay silent. He's like, my ass is going to get sued, but I don't care. He's like, Jimmy Crack Corn, I don't care. I don't even know what that song comes from, but that's what came in my head. Jason Alexander gets sued, and I don't care. He's like, fuck it. We're speaking. However, I don't know where this statement is coming from. So again, this is a text screenshotted on Twitter. I do not vouch for the authenticity of this shit. I don't know. This is what a Twitter account that I quite like is saying is said. We'll see. I was forced to sign an NDA, but cannot in good faith stay silent about the things I saw happening. Even back in the day, we all saw signs of Jamie's greed. He had his daughter on a tight chain then, just like he does now. I don't want to get into too much because it ain't my story to be telling. But when Britney does finally do an interview or write a book or whatever she chooses to do, if she chooses to do that, I can say with fact that the things she reveals will be bone-chilling to the core. Her testimony last week doesn't begin to scratch the surface of everything she's been and had to endure, and it goes beyond the 13-year conservatorship. Jamie Lynn also hasn't had a conversation with Britney in almost a year, so I don't know what that brat was spouting off about yesterday. I know I'm really just an outsider in all this, and most don't care to hear my opinion, but I think at this point, it's obvious that everyone only wants Britney happy and healthy. Agreed. Can't verify the veracity of that. Don't know where it came from, but let's see what Free Britney says. I don't know if this was sent to them. The under an NDA sounds accurate, but we'll see. So that's the statement. All right, let's go to the court of public opinion, which was, I forgot to do the thing. I'm doing the thing. We're doing the thing. All right. Court of public opinion. This one was good for you. Good for you. Does the phrase good for you, like, oh, good for you, is it always an insult? Like, is it always a condescending insult? Does it depend on tone and context, or is it a nice statement? Like, can you say good for you and genuinely mean it? Or is it always like a backhanded, like, "Mm, good for you." So look, y'all, 87% was like depends on tone and context. Pixie Dust says, I've never said it negatively. I have had it said to me that way. I always add other words or they see my face to know I'm happy or proud. Growing up, I had a relative that would say good for you, and it was more of a passive statement. And I had to learn that others didn't have to be over the top when something happens. Good for you is like bless your heart. There are multitudes of nuance with both, but in my world, both in my world are not nice. So it just depends. Yeah, I think it depends. Good for her. Fair. It's a fair meme. I can't help but think about the good for her meme. I always mean it in a positive way, but I can see how some could take it or see it as sarcastically. Sometimes I'll say to myself when no one hears me, got to put good vibes and positivity out in the world. And when I do that, I generally put good on you. Tone and context, same as the word actually. Actually is always, I mean, maybe it's just my sarcasm in my brain that hears actually like, actually, maybe it's just my kid. Because actually in my house is always like, actually. All right, let's go to the votes on the YouTube. Over 5,000 votes. I just put this up this morning because I really didn't feel well over the weekend and totally forgot to do it. The story of my life. Emily doesn't feel well. I like, after both shots of the COVID stuff, I didn't feel good. And then to get like a sinus infection, I'm like, I'm ready to be free of the yuck. 91% depends on tone and context. It's a nice statement. It's an insult. So it depends. It depends. It has the potential to be hella passive aggressive. Yes, it does. Sometimes it's a sincere affirmation. I told him to get lost. Good for you. Other times it's condescending and passive aggressive. I don't care what you think. I'm going to do it anyway. Good for you. It's fair. So when I say it, I mean it. I'm not being sarcastic at all. Now, bless your heart is a different story. I think bless your heart is meant to be, but sometimes good for you. It's like bless your heart. 90% of the time, it's a backhanded compliment. It's a compusult. It's like good for you. It can be sarcastic and mean or a genuine compliment. Right. Good for you. So good for you. It depends on nuance. This is the problem with social media. There is no nuance in social media. And so when you say good for you on social media, you need a tone indicator because there's no way to know if you mean like, oh my God, good for you. Or if you mean like, yeah, good for you. So I think we've explored thoroughly what happens. I have definitely been neti potting. Don't you worry. I'm definitely trying to get rid of the yuck. So I think context matters. Tone matters. And it's getting rainy. We've got some weather coming through today. I don't know what's happening, y'all. Today was kind of a mess. I apologize for those of you early in the stream, because it was a rough start. It was a rough start. Oh, That's Nice is wicked. Maybe we'll have to do That's Nice next week. Because That's Nice is like, is that nice? Is That's Nice ever nice? Is it ever? So anyway, good for you. It's like me with streaming this morning. It's like, oh, good for you. There's just going to be random happenings on the internet. You guys, I am going to be low key this week until I get rid of all of this gunk. I just have got to feel better. There is no new Emily show on Wednesday because I released it early over the weekend. So this week's came out on Saturday. So that is what it is. I will be back for Friday Night Live. If you want to see me around the social medias, just follow me at the Emily D. Baker. As I am feeling better, I will be on social. Maybe we'll do some little behind the scenes of what else I've got going on today. Maybe. I make no promises. I will definitely be posting more of these two little snuggle buns. I'm going to go take a picture of them and post it onto Instagram so you guys can see what they were doing while we were doing our live stream here. What else? That's it. It's a low-key week. Oh, wait. We have a members only live stream, I think, this week. I'll put it up in the chat. Me forgetting that we do it the first Thursday of the month, and Thursday happens to be the first. I knew I'd forget something. So we have a members only live stream on Thursday. Members only live stream. We're going to talk a little bit about the goings on the internet. We're going to talk about the dangers of relitigating stuff. The members only live streams, we tend to get into the internet drama a little bit more than just in the regular content, because that's when we get into the law stuff. So Thursday will be our members only live. I will put it up in the community tab. We kept bumping our members only Zoom calls, so there will be 2 of them kind of close in time. We will do one this month and one in July and one in August to get caught up, because I had been under the weather. I had been. So that's what's happening there. What else? That's it. That's the week. So I will see everyone back here for Friday Night Live. We will do a weekly roundup and check in with the world of the lawsuits. I'm going to pull that Mike Tyson suit and see if it's the same lawyers. We'll talk about Triller a little bit more. And then we'll be there. I will see. Oh, do you see? I got poked to do IV vitamins and hydration to try to knock this cold out, and now have a massive bruise. Cute, right? Super cute. Members only live stream on Thursday. It'll be in the community tab. If you want to be a channel member, go ahead and join. The members only live stream is open to all levels of membership, and we're going to go. I got to go. I appreciate you guys. I will see you around the internet this week. Thank you. Thank you. Thank you. Thank you for being honored. I will see you soon. Bye. Connect with me everywhere. I'm at the Emily D. Baker. If you guys want to join the text, just text Emily.com. If you want to join the channel, lawnerdsunite.com. Happy to have you. Support what we do here on the YouTube.